The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good afternoon, everybody. Welcome to the Fourth Circuit. We have three cases on the calendar for this afternoon, and we'll begin with United States versus Leggins. And Mr. Gavin, whenever you're ready.
Thank you, Judge. Are you able to hear me?
Yes, sir.
Yeah. All right. Thank you. Judges and Mr. Wang, may it please the court. I represent Chikosi Leggins. My name is Charles Gavin. We have three primary arguments. The first argument is based on sufficiency of the evidence, and because I believe that's Mr. Leggins' best argument, I'm going to try to spend a little time with that. My thought and my argument is that the evidence was insufficient as a matter of law to convict Mr. Leggins on count 5. The more specific argument is that the government failed to establish substantial credible evidence that the specific sexual act which was alleged in count 5 actually occurred. If it didn't occur, then there's no evidence to establish that it was false. If it was not a false statement, or if it was not established, then the falsity element of 1001 could not be established. To further dial in on that, my argument is that in particular, there was no specific substantial credible evidence that supported the finding of penetration. And penetration was required because it was contained as part of the definition of sexual act upon which the conviction was based. There were two statements, and both of those statements were predicated on the existence of a sexual act, which would have required penetration. So for the evidence that applied to penetration, there were essentially two components. The first component was the victim's testimony. The second component was the physical evidence and the scientific evidence that was recovered in a rape kit exam that happened after the incident alleged to have happened on May 10th of 2018. So in looking at the scientific evidence first, you see that right after the incident, the victim was transported to St. Mary's, and an extensive rape kit was done and analyzed. And most importantly, nothing was shown, nothing was found. There was not one evidence or evidentiary item that established that there was a tear in the victim's anus, not so much as a skin cell broken, no subjective evidence of pain. There was nothing to support any penetration at all. The best and most significant piece of evidence for the United States was the existence of DNA somewhere around the victim's anus, but we don't know where, and we don't know how it got there, we don't know when it got there, and we don't know the medium in which it was transported there. So there is evidence that there is DNA there, but there was nothing else to substantiate the allegation of actual penetration. There was no internal test done because the evidence, frankly, was so inadequate that an internal test was not even justified by the examiner at the time.
Mr. Gavin, can I ask you, the victim testified to the sexual act. We can't take that testimony by itself as being sufficient?
Well, that would be the second component, Judge Diaz, and I was going to, the next part was, is that substantial and credible? The jury acquitted the defendant of 4 other counts that were based on the victim's direct testimony, which they obviously discredited as incredible. If you look at the specific testimony in regards to the May 10th incident, the testimony is so over-exaggerated, it's incredible, and I say that specifically. The victim indicated under oath in affidavit almost immediately after this that he was forcefully and anally raped for 5 minutes in and of itself in that office room back on May 10th. The entire time that they were back in that corridor, which we know, does not rely on his credibility, was 315 seconds. That's the time they entered the corridor until the time they exited. I introduced an expert, not an expert, but an investigator who testified that just the simple act of walking from one place to the next and exiting would have taken up 70 of those 315 seconds. So what the defendant in his version has alleged is that he was forced to go back into the office room. He was forced to perform oral sex on the defendant for a period of time, after which they then moved to a different section of the room after which he was forcefully anally raped for 5 minutes, according to the victim, after which they cleaned up, after which Mr. Leggins had to go to the restroom, and then after which they departed the other side. Now, according to that version, all of that would have had to happen in less than 4 minutes, which is just simply incredible. And that's what I was able to argue to the jury. And I believe that is what the jury agreed with me upon, is that it just didn't happen. So if it didn't happen, then the evidence from the victim side can't really be considered as credible in light of the absence of any physical evidence that would corroborate that. So, Judge Diaz, I would say to you not only that the physical evidence to support it, but the actual testimony of the victim is not substantial or credible enough, specifically and especially in light of the jury's verdict on the other 4 substantive accounts, to render his testimony credible.
You mentioned the verdicts, and admittedly, they're, they, at least at first blush, they do tend to be inconsistent. But I mean, there are all kinds of reasons why a jury might acquit on one count and convict on the other. What leads you to believe that the primary reason for the acquittal was that by the jury was that the jury simply didn't believe the victim's testimony?
Well, it's are you going to gore my oxen or Mr. Wang's oxen? I think under the Lothian case. But, I agree that the case law still is out there that an inconsistent verdict does not necessarily win me the day. But even though it does not win me the day, I think to gore my ox, you still have to establish, and the government was required to establish, that there was substantial credible evidence that the underlying offense took place. And that takes me back to whether or not there was actual penetration. Because if there was no actual penetration or no established substantial credible evidence to establish penetration, then the falsity element was never established, and he should have been acquitted of count 5.
Well, I may have just absolutely misunderstood this case. I thought the key issue in here was the Apprendi issue in Eileen, in that the indictment did not contain any allegation about the enhancement. And in order for him to be subjected to it, that's an element that the jury would have had to find. I mean, isn't that the real issue in this case?
That's the second issue of the case, Judge Floyd, and the issue arose out of the fact that after the verdict was in, Judge Novak realized that the arraignment on the record was 5 years, and based on the 5-year standard 1001 penalty, but then based on it being a sexual act, quote unquote, that would have subjected the defendant to an 8-year penalty. So it's an issue of whether or not he constructively amended the indictment, or whether he just failed to instruct the jury as he should have to include that extra element. Because I agree that the indictment does contain the basic elements for a 1001 offense, but under Apprendi, in order to convict the defendant of a crime that would have increased his level or to an 8-year max, then the actual wording of that relates it to a chapter offense under 209A would have had to have been included and would have had to have been established as an element in the actual trial.
Mr. Gavin, can I ask a follow-up to that? So, and I get your point that you say that the evidence simply was insufficient to prove a sexual act. But if we disagree with you and conclude that the jury did in fact find that a sexual act was committed by your client, doesn't that answer the factual question that Apprendi is concerned about? I mean, the question as to whether or not the offense relates to one under Chapter 109 seems to me to be a purely legal one, that it wasn't necessarily, or should not have been necessarily, part of the jury's calculus.
Well, Judge, if I understand your question, as I understand the law, if it's going to increase the maximum from 5 to 8, then it's an element that has to be submitted to the jury. And
no, I don't disagree with that. The question is exactly what was it that the jury had to find? That they have to find both that a sexual act was committed, and then the obvious connection then follows inevitably that it was in fact that offense relates to chapter 109. There simply can't be any dispute about that. Or do they have to find both?
They have to find both. That's my argument. They have to find that the sexual act was committed, otherwise it wasn't false. They also have to find that the offense was specifically related to 109A, and that was not given to them. The instruction.
Can I follow up on that? Because it seems like words matter here. And you use the word offense is related to 109A, but I read 1001 to say that the matter must be related to 109A. And I read matter to refer to the investigation, not the crime. Is that not the right way to read that portion of 1001?
Judge Richardson, I would agree with you. That was a poor choice of words on my part, but it's still at the end of the day.
But help me understand if that matters, right? Because if the question is, does the offense or the statement relate to 109A, you got a really hard argument to make because, for the reasons Judge Diaz described. The challenge is that it's a slightly different question of whether the investigation related to 109A. I mean, we know for sure that it did. But at least in theory, you could have asked a sexual question in a drug investigation or some other public corruption investigation. And so I took your point to be that the government needed to prove that the investigation was related to 109A and that's just, might be true. In fact, we all know it's true, but we don't have that in the indictment and we don't have that before the jury.
That's correct, Judge Richardson. My point was that the jury instruction that was given to the jury did not define sexual act for this particular count. It also did not include any language in the instruction that included as an element that the matter, in your case, be related to 109A.
Can I ask a related question to that then? You seem to make a jump here by saying in the 1001 count that the phrase sexual act, it has the definition that is used in the federal code, right, of penetration.
Yes, sir.
But why would we think that as opposed to thinking the term sexual act has its common and ordinary understanding in the context of a discussion with FBI agents and not a legal question? And so the jury was able to interpret sexual act not so limited as the federal code might suggest, but in fact in the more common and ordinary understanding, which is not limited to penetration.
Well, to answer the question, we don't know. You could be right, Judge Richardson, that that's
a legal question, right? So the legal question is, did the jury have to apply the federal code definition? Nobody suggested it. You didn't argue that below. Or was the jury entitled to apply its own understanding of sexual act to whether that statement was false?
I believe that the jury was required to be at least given a definition as to what a sexual act would be, whether or not that's the code language or whether or not that leaves it up to their interpretation of what sexual act is. They were not given any instruction on the definition.
Did your client request an instruction?
We had no reason to ask for an instruction at that point because when we were arguing in front of the jury, this issue of the 8-year versus the 5-year wasn't on the table. That happened after the verdict. I see my time is almost up. Is there anything else that I can address to the judges?
Judge Floyd, do you have anything else?
No, sir.
Okay. I saw Judge Richardson shake his head no, so I'll take that as a no. Thank you very much, Mr. Gavin. We have some time left for rebuttal. We'll hear from the government and Mr. Wang. Mr. Wang, we can't hear you.
Can you hear me now?
Yeah.
Thank you, Your Honor. May it please the court, Christopher Wang on behalf of the United States. The evidence showed, and the jury found, that Leggins lied to federal agents investigating whether he sexually abused an inmate in an unattended, unsurveilled prison office after hours. None of Leggins' arguments on appeal warrant the overturning of his conviction or sentence on the false statement counts. Now I'll turn to the sufficiency issue because opposing counsel spent much of his time there. There are two independent bases to uphold the Section 1001 conviction. First, that Leggins falsely...
Can you start with the question that I asked your colleague? Your colleague's argument seems to be premised on the idea that sexual act, for purposes of 1001 charge, this 1001 charge, requires penetration. I don't know where that comes from, but what's your interpretation of sexual act? Is it limited by the code's definition, or is it a contemporary ordinary understanding of the jury?
Your Honor, we agree with your position that it's the latter, and we come to that conclusion by looking at both the indictment and the jury instruction. For counts 1 through 4, both the indictment and the jury instruction specifically define sexual acts in terms of the definition in the statutory code. We find no such definition in count 5, either in the indictment or the jury instructions. And to us, it makes sense that you would not limit the definition of sexual act to penetration in the course of determining whether defendant obstructed justice under Section 1001. Certainly, a lie about whether he engaged in any kind of sexual activity at all, regardless if it was penetrative, would have a tendency to influence an investigation into whether he sexually abused an inmate. So, yes, we would agree with
it. And this is maybe a little speculation on your part, but I'll ask it anyway. Is that a theoretical explanation for the otherwise seemingly inconsistent jury verdict?
It is, Your Honor. We think it's quite possible that the jury could not find beyond a reasonable doubt that Mr. Leggins penetrated BL, but we think that it's, given the evidence in the case, it's quite likely that they did find beyond a reasonable doubt that there was some kind of sexual activity, even though it was not penetrative in that office.
And Mr. Wang, is the enhancement under 1001 an element of that offense?
It's not an element of the offense.
What is it then?
It's a means of increasing a sentence that we have the
wait. Stop. Now, you got plenty of good arguments.
Yeah.
But it is really your argument that it's not an element after Aline?
Let me rephrase. It is an element, Your Honor, and we believe that the factual predicates for the enhancement were established in the indictment. Basically, at the time of the indictment, Mr. Leggins knew that he was a subject of an investigation into possible sexual abuse of an inmate, and as Judge Richardson, as you indicated, it's 1001. You read matter to indicate to be the investigation. Therefore, you look at whether the false statements were related to the investigation related to an offense under Chapter 109A, and they clearly did, because they were investigating whether.
So then answer what from the indictment tells us that this investigation was into sex crimes instead of drugs or something else.
Well,
how do I know that from the indictment?
The fact that it's mentioned sexual acts 3 times, the fact that you can look at the count number 5 in the context of the entire indictment, in which he was being prosecuted in counts 1 through 4 for various sex abuse crimes. We think that.
Well, but that shows the end result, right? But if they were investigating a drug crime for one reason or another, we might not expect FBI agents to ask about sexual activity in a drug investigation, but we can certainly imagine reasons why it might be relevant. The trouble I've got, and I get as a factual matter, you're there, but I need to look at the 4 corners of the indictment and be able to say that the matter I read as investigation was related to a 109A investigation. And I don't see that I don't see that in the indictment. I certainly don't see that in the jury instruction. But I want you to tell me what am I looking to learn that piece of information?
Your Honor, again, I return to, you look at the actual language of count number 5. You've got 3 mentions of a sexual act. You've got the reference to the FBI, the joint FBI DOJ investigation. At the time that Mr. Leggins was indicted, he was well aware. He was told at the beginning of the interview that he was a subject of an FBI investigation into possible sex abuse of an inmate at FCI Petersburg.
Right. No, but again, this is conflating the facts. I get as a factual matter, you got a really great claim.
Yeah.
The problem is like the formality matters here, right? And the indictment does talk about sex. It also talks about, computer, online computer and printers, right? So maybe it was a computer crimes investigation for all I know, because it looks at matter and it tells us what the matter is, but it defines the matter as a general matter within the jurisdiction of the FBI. That's it, right? It doesn't tell us what kind of matter it is beyond that. And so that's, do you understand my?
Yeah, I see. Do you see your issue? I mean, sir, I didn't interpret opposing counsel's argument to argue that the validity of the indictment. I sort of interpreted his argument to focus on the validity of what he was informed at the arraignment. But
an Alene error or an Apprendi error is fundamentally about what's in the indictment and what's in the jury charge, right? I mean, that's correct, Your Honor. That's what an Alene error is. So maybe I'll ask one more question and then maybe I'll let my colleagues go. But assuming that I disagree with you on the merits of this, and I think it is an Alene error. First, have you argued harmless error?
We did argue harmless error, that even if he was entitled to the information, the correct information about the maximum statutory sentence, the fact that he did not receive the correct information doesn't make a difference, because he would have. There's no evidence that he would have pled guilty instead of proceeding to trial.
Right, so that's the question I want to ask, and I take it that you did. It seems like you did in your brief, but the question I've got is a slightly different. Is what do we look for harmless error? And if you don't know the answer to this, it's fine to just say I'm not following you. It's totally fine. But there are two lines of cases that we have. One represented by the Supreme Court's decision in Netter that says if you fail to instruct a jury on an element, we can look at the evidence to see if the error is harmless. And so that's one form of harmless error in this type of problem. And at least in a case called Catone, we apply Netter to Apprendi errors, which are Alene errors. And so is that the harmless error that you're advocating for? Or separately, are you arguing that the error is harmless for some other reason?
Well, we're arguing that the error is harmless because it would not have changed the defendant's trial strategy. I don't know if that falls into your Alene box or not.
Do you believe that you can show harmless error merely by showing the facts that are relevant or uncontroverted and overwhelming? Is that sufficient to show harmless error from your perspective?
We do, Your Honor. With regard to Apprendi, my understanding of Apprendi is that it only applies once the district court passes sentence, and if it, imposes a sentence greater than the statutory maximum, then you have to look at whether, the facts that led to that sentence above the statutory maximum were presented to the jury and proven beyond a reasonable doubt. But here we have a sentence that was 54 months, which was below the 60 months statutory maximum for even a standard Section 1001 violation. So I'm not sure how there was any Apprendi violation here.
But he was, Alene says that the error is not the sentence, the error is the improper range, right? And so he had an improper range, hypothetically. I know I'm not asking you to concede that, but he had an improper range. And normally, if it's under the old statutory maximum, that would be harmless. I get your point. But here, we've got a little bit of a wrinkle because the guideline specifically enhances his sentence as a result of the higher statutory maximum, right? And so what I have a hard time understanding is why that isn't the error, unless, the overwhelming and uncontroverted evidence point gets you out of the box.
Are you talking about the 3-year enhancement from 5 years to 8 years?
I'm talking about the 4 level enhancement as a result of it being an 8-year max offense instead of a 5-year max offense, right? There's a 4-point guideline enhancement, right?
Okay, yes, the 4-level enhancement of section 2J 1.2, I think
Exactly.
you're talking about. Okay, I think my interpretation of this enhancement is that it applies so long as the matter is related to a sex offense under Chapter 109, and the matter is the investigation.
Right, so help me understand how I get there, because it says it applies if you're convicted under 1001 and, quote, the statutory maximum term of 8 years applies, right? So that sounds to me like it's actually referring to whether the statutory maximum term applies, not the underlying facts.
Well, I've got section 2J 1.2. If the defendant was convicted under section 18 USC 1001,
Would
and
you agree
statutory maximum term of 8 years imprisonment applies because the matter relates to sex offenses under chapters 109A and so on and so forth. So what I think how you apply this particular enhancement is you look at the matter, as your honor previously suggested to opposing counsel, and the matter is an investigation into his possible sex abuse of an inmate, and that related to a sex offense under chapter 109A. So the 4-level enhancement would apply here.
So your argument is that it doesn't matter whether the 8-year statutory maximum actually applies. If it could have applied, then you think this section applies?
That's my reading of this 4-level enhancement.
Okay, but if and I'll stop because I've hogged your time and I want to give my colleagues an opportunity. Do you agree if that reading's wrong that your harmless error fails, or do you think it still depends on the neater point of whether there is uncontroverted and overwhelming evidence?
I don't think it necessarily destroys our harmless error argument. I mean, our harmless error argument is based on, the fact that this, whether he was informed of 5 years or 8 years would not have changed the decision to go to trial, because he was facing possible imprisonment of life if he was convicted on these other offenses. I'm not sure if that answers your question, but that's sort of where we are on harmless error position.
Mr. Wayne, could I, if just throw up so that I understand this, because now I'm a little bit confused, but that's a different harmless error analysis than the one that I don't want to put words in Judge Richardson's mouth, but I think what we're trying to figure out is whether or not there is in fact uncontroverted evidence of the underlying sexual act that Mr. Gaston says completely fails for lack of proof. And so can you answer that question?
Yes, Your Honor. If you take our position is that the sexual act, as Judge Richardson noted, is not necessarily penetrative sex as defined by the statute, but sort of the common ordinary definition of sex that an ordinary juror might apply. And the evidence that we have right here is first the obstructive behavior of Leggins in taking BL into an unattended, unsurveilled office after hours. We have BL's trial testimony in his contemporaneous report of the assault to his cellmate, 2 FCI officers and 2 nurses. We have the DNA evidence, including the DNA of the anal rectal swab of BL, the inside of his jockstrap and the outside of his shorts. And we have the IT manager's testimony regarding the implausibility of Leggins' account of his conduct in that office. So I think if you view all that evidence in the light most favorable to the government, certainly you come to the conclusion that he engaged in a sexual act as the ordinary definition of sexual act and lied about it. And I'd also like to sort of bring up the point that there's another independent basis to uphold the section 1001 conviction, which is that Leggins falsely stated that he was engaged in quote unquote just conversation with BL while in that office and while he attempted to use a computer. And that there's sort of uncontroverted evidence from the IT manager that no one attempted to log on to the computer during the time that Leggins claimed to be in that office using the computer, and his story of inserting his PIP card and being unable to input his PIP number was implausible. So certainly, if this court has certain reservations about upholding the section 1001 conviction based on the false denial of engaging in sex with any inmate, it certainly could turn to the false statement about engaging in just conversation to uphold the conviction. I'd also like to add that Mr. Gavin, I think, made said a lot about his about the so-called evidence of how it was implausible to walk the victim through the corridor only 315 seconds and to rape him for 5 minutes. Certainly, that was an argument, and all that evidence that opposing counsel presented to the jury that the jury already considered and rejected. And viewing the light and most favorable to the government, this court should reject as well.
Mr. Wang,
Yeah.
Based on the way the indictment was written, is it possible that the jury was convinced beyond a reasonable doubt that he did lie about the computer, and they just glossed over the sexual nature?
Well, the
indictment, they weren't told you've got to find the computer lie and the sex act. So is it possible that when they got to the computer, they just found him guilty, and that's the end of it?
It's possible, Your Honor. It's impossible to speculate about what exactly.
Wait. No. There's a special verdict form, right?
Yes, that's correct.
Right, and the special verdict form, they have to check which lie, either or both, and they check both statements as being lies.
That's correct. I was interpreting Judge Floyd's comment to mean maybe they just glossed over the second lie after finding the computer lie and just didn't give it much thought and checked yes. But we can't really speculate about what the jury was thinking. We have to look at the face of the verdict, and the verdict indicates they found both lies, both that he falsely denied engaging in a sex act with any inmate at any time, and that he falsely stated that he was engaged in just conversation with BL. So I think we have to just look at the face of the verdict form and say that we think the jury did their job and came to those determinations, and basically you can rely on either one to support the section 1001 conviction. Your Honors, if you have any other questions about, I see my time is running down. If you have any other questions about the sufficiency, the statutory maximum sentence, or the procedural and substantive reasonableness of the sentence, I can answer them now. If you don't, I'll just rest on the briefs and respectfully request this court affirm the conviction and sentence. Thank you.
Thank you, Mr. Wang. Mr. Gavin?
Yes, sir. Thank you. Judge Richardson, to address your comments about whether or not this is something that the jury could infer from a common sense approach based on their understanding in the general world of what a sexual act is versus what the statutory definition is. It would be fine, I think, if they had been told you can rely on your own inferences that you obtain from common sense daily activity, but they were only told sexual acts. And sexual acts was defined throughout in counts 1 through 4 uniformly. So there would have been no other way.
Doesn't it say when he gives the instruction, and this is my experience, I haven't pulled this particular charge, but don't they say for purposes of counts 1 through 4, sexual act means? And so
they did that in each count.
Right. And so the point being is that means it doesn't say that for count 5. And the sort of reasonable interpretation there means that sexual act means, what a lay person's understanding would be for count 5.
If that was the case, then they would have to have gone beyond the jury instructions that they were given, because there wasn't any definition provided to them, and there wasn't any instruction that was provided to them that would have said.
I mean, they didn't provide instruction. They never provide instructions on every word in an indictment, right? Or the instructions are always subject to interpretation. Right? Why is this different from all the other words that they use?
Because in this
every phrase.
Because in this case, Judge, it was an element. I mean, to get an enhanced penalty, it was an element. I mean, there are 4 elements under the basic offense, but it should have been a 5th element they would have instructed upon to establish that the matter was an offense covered under 109A. They were only given instruction on the first 4 elements.
Mr. Gavin, I'm not saying this is going to be the result, but assume that we uphold the conviction on the computer lie. what would you have us do?
Judge, if you uphold the conviction on the computer lie, then I would have the court at a minimum re-sentence the defendant based on using a 5-year maximum. That may or may not create prejudice to defendant because I agree that his ultimate sentence was less than the 5-year maximum, but the prejudice was the fact that he was given an additional 4 levels under the sentencing calculus based on it being an 8-year term. So the judge started in the wrong spot. What I would say to you, Judge Floyd, is that I don't know how the computer cannot be intertwined with the Sex Act because there's an additional sentence in that indictment. The additional sentence in the indictment basically says, yeah, you lied to us about going to a computer and a printer when you knew you had engaged in a sexual act with the inmate. That's the last sentence. That was not included in Mr. Wang's argument. So the two are intertwined.
Well, wait. But it says that, but it also says separately that the defendant used an unintended office with no surveillance cameras. I mean, that's the point is those go together, right?
Well, I think you have to read it all, but there's like 3 different clauses to that language in the indictment. So, if we're going to have a special verdict, that's not what they included in the special verdict because the special verdict form was not that specific. Whether it was that part of the clause or whether or not because he had engaged in a sexual act clause or whether or not they were in an unintended office with no surveillance cameras clause. I mean, there's 3 different parts to that clause, but the underlying premise is that he knew that he engaged in sexual acts. Frankly, and this is not
Mr.
part
Gavin,
of the argument.
And I guess this is part of your point. Even that last clause says that he used an unattended office with no surveillance camera to engage in a sexual act with the victim. So even that clause is sort of dependent on the jury somehow finding that that was the purpose of using the office.
Correct, Judge Diaz. And if you take that another step, if there was no sexual act established, then who cares why he was in the office? Who cares whether or not he used a printer or whether he didn't? At that point in time, the issue would be that wouldn't be material. I didn't raise that because I believe that they're so intertwined that they are based upon the establishment of a sexual act. That's the root cause of the lie. That's the root cause of the harm. If there was no sexual act, but he lied about just going into an office for a printer, I'm not sure that would be material enough for a conviction. So that's my thought on the fact that I believed that even though there are 2 different counts, they both are predicated upon the establishment of a sexual act. And the issue of just the alibi or the cover up is really immaterial to the real substantive act, which is because he had engaged in a sexual act.
So, Mr. Gavin, let me follow up with this is part of Judge Richardson's questions. If we find, in fact, that the evidence sufficient, that there was, in fact, a sexual act as required by the code, taking the definition that you say would be required, not just any act, but the sexual act that you say is not supported by the evidence. But if we conclude otherwise, is this Apprendi error harmless?
I don't believe so. I mean, I think the error that Mr. Wang was talking about, which, whether or not Mr. Leggins would have chosen to plead guilty or not plead guilty if he'd been given the correct statutory max, might be harmless. But the absence of giving the jury all of the elements that were required to get the enhanced penalty under 1001 would be almost plain error under, even under the potential Medley case that you guys have pending now. It would seem to me that that's a constitutional issue under the 5th and 6th Amendments, whereas he has a right to have the grand jury indict him with appropriate language, and he has the right to the jury have to consider the appropriate language once written. If Judge Novak essentially changed the form of what the grand jury issued by essentially extending the 5-year term to the 8-year term, I think that could be considered under the plain error. I see I only have 30 seconds, Your Honor, so.
My colleagues have any further questions?
No.
Thank you. Thank you, Mr. Gavin. I note that you were court appointed, and so I want to thank you especially for taking this case on. I think your client was very ably represented by you today, both here before us and on the papers. And Mr. Wang, thank you as well for representing the government's interests. As you probably know, in normal times, we would come down and shake your hands and thank you personally. We can't do that, but hope to do that again real soon. But in the absence of that, you have the thanks of myself and my colleagues for your able work on this case. So thank you very much.
Thank you, judges.
All right, we'll move on to our second case.
Will be brief. We've seen this movie before. The court has seen it any number of times. My dear friend, Judge Terry Boyle, has had a dozen or more of these cases in Richmond. They have all come out the same way. They have all been remanded by the court for resentencing and re-explanation, or in some cases, explanation for the first time of just why he picked a particular sentence. The Provence case, United States against Provence, which this court decided in 2019, is the most significant case in the briefing. Judge Thacker, I believe, wrote that opinion, and she noted that we have held sentences with more explanation to be procedurally unreasonable. This court is simply left to wonder, left to speculate on why Judge Boyle picked a particular sentence or did not pick a particular sentence. And there are a number of other cases cited in the brief. And if those cases are remanded for resentencing and a better explanation from the district court, I simply don't believe that there's any way around having a resentencing in this case. Now, this court asked for the supplemental briefing on two issues. One of them was the adequacy of the district court's explanation of the sentence. And I think that is clear as a bell here. And again, I think resentencing is absolutely mandated.
Mr. Craven, can I ask a question about that issue? So it clearly, Judge Boyle didn't say very much in this case, but I think we have to take each case on its own merits. And so the context here was an argument by counsel below, and I don't think you were the lawyer below, but
no, I was not.
Essentially said asking for a downward variance on these for two reasons. One, that he was a young man with no prior felony convictions, and that he had significant support in the community. And that as I understand it, was the sum and substance of the case in mitigation. And I'm not downplaying that, but that's essentially what he said. And then the government responded by pointing out that the circumstances of the offense, including that he arranged for over 15 different drug deals, and that there was a child present at one point, I guess, in the house when he was dealing heroin, and that the violent crime incidences in his neighborhood had gone down significantly since Mr. Suggs and someone else had been removed from that environment. And the judge, after hearing all of that, essentially said that the government had satisfied their burden, and a sentence within the guideline at the low end is appropriate. Now, can't we simply infer that essentially Judge Boyle said, you know what, I hear your argument, Mr. Suggs, about why a downward variance is appropriate, but I think the government's rationale for why one is not appropriate is a better one, and therefore I'm going to sentence within the guidelines. Isn't that essentially what he said?
I think that's a stretch, Your Honor. He could have made that a great deal clearer.
Well, let me ask you this: if he had said that, would that be enough?
Maybe, but I think it's a stretch to say that that's what he said. Now that's the government's argument, but the Judge Boyle talked about the government satisfying its burden of proof under 3553A.
Mr. Craven, let me ask you this question. I think that's what you're telling us, but at JA 59, I think, if I'm wrong, the government can correct me. I think the only thing Judge Boyle says, I think under 3553A, the government has satisfied their burden of proof and a sentence within the guideline at the low range is appropriate in this case. Did he say any more than that?
Did he say any more than that?
Yes, sir.
No, sir. That was the extent of the explanation. And I would say to that the government had no burden of proof under 3553A. The burden imposed by 3553A is on the district court to explain its sentence. And Judge Boyle went from that sentence that Your Honor just read to the very next line is, I'll impose a sentence of 63 months. No explanation whatever. And so I don't think he went far enough. Now, I know the government disagrees with me on that, but I think this is virtually identical to Provence and Limas and Carter and a number of other cases. And if we're going to remand, and I understand what Judge Diaz said, and I agree, we have to take each case separately. You know, none of them are completely on all fours with one another, but they're very, very similar here. And if we're going to remand those cases for resentencing, I don't know how we can avoid doing that in this case. I really don't. And Judge Floyd, I think you put your finger on it right there.
Do any of those cases, I mean, you know, I take your point to be, it's not, burden of proof is not really the right language. But, you know, I mean, when I read that, I read it sort of naturally to mean that, you know, I agree with the government. The government's won out here.
That is certainly one interpretation of that. But to some extent, we are left to speculate. Judge Boyle could have, and we suggest should have, spelled it out with much more specificity than he did.
So I agree with both of those things. He could have and should have. The question is whether he was required to. Right? I mean, I can agree with you that he could have, and I can even agree with you that we would all like for him to. But was he required to is really where I'm getting at. And if he says the government's got the better of the argument, why isn't that enough?
Well, I don't think he said that. I think he stopped short of saying that. Is that implied? Yeah. But again, you know, how are we gonna remand Provence for resentencing and not remand this one? They're just virtually identical. They really are. And again, as I began with, we've seen this movie before, a dozen or more times just in the last couple of years. And this court has expressed.
But we have in Provence itself, right? There's no reference to the government's argument, right? He just says, "I'll impose a sentence of probation of 5 years." Right? I mean, he doesn't say, I mean, you know, anything from which we could imply that the government's got the better of the argument.
No, but it was after he sentenced Provence after the government had made its argument.
Right, but I think the point of Provence is you got to give us something.
Yeah.
Right, and the question is the implication that the government got the better of the argument not enough?
I don't think it is enough, and yeah, you're right. He's got to give us something to go on, or we're left to speculation. I don't.
Isn't it
think-
also doesn't Mr. Craven? Doesn't it also matter that the sort of the extent of the case that's presented by the defendant? I mean, in Provence, it was a little bit more, maybe not a lot more, but certainly a lot more than what's presented here. I pointed out what I thought was the gist of the defendant's argument here, that he had taken responsibility and that he was young and the like, and that was it. I mean, that's an argument that's made virtually in every case. And again, I'm not denigrating that, but there really wasn't anything all that significant about the defense argument that required the judge to say a whole heck of a lot.
I think had the defense made no argument at all, the district court still has the obligation to explain the sentence with some degree of specificity. Now, the weaker the defendant's sentencing argument, probably the less the district court has to provide in the way of explanation. But I think this court, right now, with the record as it is right now, is left to speculation. I really do. And I see my time is up, but.
All right. Thank you, Mr. Craven. You got some time left for rebuttal. Let's hear from Ms. Brown.
Thank you, Your Honor. A sentencing explanation does not have to be lengthy to be sufficient. The government understands this court's preference, stated even here today, that this district court would provide more explanation, but what was provided in this case was sufficient. All the more so because, and this is an important point that has not been mentioned by my colleague, this was a guideline sentence in a typical case. The explanation wasn't long. The government recognizes that. We would never say otherwise. But the words that were said did a lot of work. They did the work that no one who left that courtroom that day, least of all the defendant, had to leave scratching his or her head and saying, why did I receive the sentence that I did? And under the prevailing Fourth Circuit and Supreme Court case law, this is enough. And that's why we ask that this case be affirmed. At sentencing, as Your Honor mentioned, Judge Diaz, the defendant made limited arguments under the 3553A factors. Those arguments, limited though they were then directly and effectively countered by the Assistant United States Attorney head on. The court then weighed the two, and the government agrees with Judge Richardson's explanation just now that this was the judge essentially saying, I've weighed these and this is one out. Was it a model of the most articulate way this could have been said? I think we'd all agree no, but it's clear what he was saying. I've weighed these and the government's went out, and they were directly on point to each of those limited 3553A arguments. Based on that, and with reference to the statute and the guidelines, the judge imposed a low-end guideline sentence. By incorporating by reference those 3553A arguments and explicitly referencing that low end of the guidelines, the court did sufficiently explain this sentence. Respectfully to my colleague, we haven't seen this time and time and time again. We have seen cases that have come before this court from this district court, but this case, just like the defendants below, deserves an individualized assessment. And here there are important things to distinguish this from other cases to which my colleague refers. Rita tells us that when a case is conceptually simple, as this one was, I think we could all agree, and the record is clear that the sentencing court considered the evidence and arguments, it doesn't require an extensive explanation. And here we know why the court did what it did. It told us. The court was persuaded more heavily by the government's directly responsive 3553A arguments, and they were compelling. The defendant in this case made limited arguments, as Your Honor, Judge Diaz summarized, that this defendant had no prior felonies, a limited.
Counsel, what do you do with the burden of proof? I mean, if instead of the phrase burden of proof, he had said, the government's argument, or something other than burden of proof, your argument would be stronger in my view. Well, what do you make of the use of the phrase burden of proof there?
I understand that concern and that question, and I think there could have been a more articulate way of phrasing that. I think from the whole picture, including the fact that he then imposed the sentence that the government had requested, which was dramatically different than the one that was requested by the defendant, I think it's a fair reading to say that he was saying essentially that I've weighed these, the government's is better. It's a balancing and the government's wins out. I agree there is not a specific burden of proof for the government, and the phrasing could have been more specific, but I think in the context of the whole hearing, where it's clear that the judge paid attention, considered these arguments, was very familiar with this case, and then gave the sentence that the government had just requested, that is what he was getting at by that statement.
Ms. Brown, shouldn't he have at least said, I have considered your non-frivolous, he didn't have to use the word non-frivolous, I've considered your arguments and I don't buy them.
It is the government's position that that was implicit in his preferencing of the government's arguments, that the government's arguments were specific responses to those arguments by the defendant. And by preferencing those and saying essentially those went out, the court was in effect saying that. The defendant said, I have a low criminal history, no felonies. The government responded directly on point and said, essentially, the defendant may have a low conviction history, but the defendant's criminal history is extensive, even just in this case, where he committed, according to the PSR and evidence, 15 separate felonies, just in this case, just in 2018. The defendant said, I have community and family support. The government said at sentencing, you involved a small child in a drug deal. You recruited and involved your younger brother, who was just 17, in this drug crime. And your community, according to law enforcement, has been demonstrably safer since your arrest and those of your compatriots in the Crips street gang and your co-defendants in this case. By hearing those arguments that directly addressed those two arguments by the defendant, I think it's a separate query whether those truly were non-frivolous arguments by the defendant, but they were specifically addressed by the government, and the court did essentially say the government's went out. So to the
Ms.
extent
Brown, part of the court's concern, and I'm not singling out this particular district court, but because we all know that district courts are busy and we don't expect perfection. We certainly don't expect district courts to dot their I's and cross their T's when it doesn't matter. But of course, sentencing is the most important thing that a district court can do. And so it's important that a defendant understand that his arguments are being heard and that the process works as it should. And so that's sort of where we're trying to draw the line here. And as Mr. Craven pointed out earlier, there have been some instances where the line has been drawn that required the case to go back to this district court because of a concern that perhaps the arguments were not heard. And so I guess the question is, where does this case fall on that continuum? And I hear you saying that it's not one of those cases, but are you making a harmless error argument here, or what's
we did not argue
on
harmless error in our brief. I would certainly be happy to address that if Your Honor specifically would like me to discuss harmless error. I certainly
can. You didn't argue in your brief. I don't know that you need to argue it now.
Yes, Your Honor, and that's why I didn't bring that up. But to respond to your question, Judge Diaz, you would like to hear that, I certainly would be happy to argue that. I think there are several things here, to be sure I'm referencing your original question, that do make this different and that show us, I think your question was, how does this defendant leave knowing that this judge was actively engaged in his sentencing hearing? If he doesn't say all these specific things, repeating the government, how can that defendant leave knowing he's been heard? And I think there are a few things in this case that we could point to directly and easily. First thing, when the defendant walked in, the district court asked to hear from him before anything else. And the defendant did allocute. As my colleague noted in his reply brief, or perhaps his original brief, it was nothing out of the ordinary, but he had his opportunity to be heard, and the judge thanked him for that. In this case, there was a witness who testified at sentencing in depth as to the facts. And when the judge couldn't hear the witness, the judge asked him to speak up, showing an involvement in the hearing. This isn't a case where a judge is just sitting back, watching the time pass. He's actively engaged. And he says, I can't hear you, speak up. I need to understand this. And then perhaps most remarkably, at the end of the witness's testimony, the judge recognizing that this was the 12th in time of 12 defendants involved in this case, the court questioned of the witness, isn't this exactly how this case worked? And gave a factual summary of this somewhat unusual factual basis for this particular hearing in terms of how, not the crimes themselves, but he explained to the witness, isn't this how this case worked? This was a clearinghouse. It was like a bazaar. The now defendants would bring their guns and drugs to this warehouse and conduct their transactions, showing that he was actively engaged and this defendant was being heard. The other thing in this case, and it is an important one, is the work done by the fact that this was a guideline sentence in a typical case. The guidelines this court has indeed recognized, and the Supreme Court hasn't recognized, that when a guideline sentence is imposed, and here it was a bottom of the guideline sentence, the court can give a more brief explanation than in other cases. Importantly, I would note that the Provence case was a dramatic deviation from the guideline range. Many of the cases my colleague has cited were indeed deviations from the guideline range. This was not, and that is a significant factor under Fourth Circuit and Supreme Court case law. Rita tells us that that guideline range, it's not an arbitrary range. It's designed to approximate 3553A factors. Now, of course, that's not all there is to do, which is why we have these hearings and why this and other defendants were heard on those. But for example, this defendant's primary argument was his lack of criminal history and his inexperience criminally. That accounts for half of his guideline range, which this court found appropriate in this case. So the fact that this was a guideline sentence does a lot of work in this case, and it requires less explanation under this court's case law and Supreme Court case law. The other important factor is that this is a typical case. This isn't one that was a rare aberration from cases that this court has seen many, many times. And again, under this court's case law in blue and others, as I previously cited for explanation, and Supreme Court case law, a typical case requires less explanation. This is a case that was a drug and gun case. This defendant committed controlled purchases involving cooperators and undercover officers. He was indicted, arrested, arraigned. All those processes followed the typical process up to his sentencing, where again, he was a typical case even within his own indictment as the final of 12 co-defendants to be sentenced on this fact pattern. So those things all also contribute to the fact that this is a case where a judge can be perfectly sufficient under the law with a brief sentencing explanation. We recognize that this was indeed a brief sentencing explanation, but it is our position that the court adopted, incorporated by reference. At this point, we can query whether those were even non-frivolous, given the response from the government and the way they played out in this case. But they had to leave saying, I have no idea why the judge did what he did, which was this court's finding, not in so many words, in Provence, and is another reason that this is importantly distinguishable from that case. Your Honors have not asked any questions about the Rule 11 issue. I would certainly be happy to address that, but it seems like we've been fairly focused on the sentencing explanation in this case. I think importantly, it is the government's position that when this defendant left the courtroom that day, he knew why he'd been sentenced. His family members who were there, the government, they knew why he'd received the sentence he did. And it's because the judge went with the government's interpretation, weighing of those 3553A factors, the limited 3553A factors that the defendant brought up. It was brief, but in this case, the judge did give this defendant the individualized attention he is afforded under the law. It's permitting the meaningful appellate review that this court is engaged in. And because we know what the judge did and why he did it, we would ask this court to affirm the sentence. Thank you.
All right, thank you, Ms. Brown. Mr. Craven?
Thank you, Your Honor. I agree completely with government counsel that for a number of reasons, a very brief explanation would probably have sufficed in this case. What we have, though, is really no explanation. And I would, even though she's not with us today, I would give Judge Thacker the last word in this. In her opinion in Provence, she made a point of saying, we have held sentences with more explanation to be procedurally unreasonable. And she cited United States against Blue. I agree that Judge Boyle was not required under the individual circumstances of this case to give a lengthy and detailed, endless explanation of the sentence. But I think he was required to go further than he did in explaining it. And we're all left to a large extent to speculate. We can make an educated guess as to why he said and did certain things. But an educated guess in this context is not good enough. And I think he could have and should have gone further than he did, and was in fact required to go further than he did. And unless the court has other questions of me, I'll take the rest of the day off.
Thank you, Mr. Craven. We'd like to take the rest of the day off, but unfortunately we have another case right behind this one. But thank you, Mr. Craven. I see here that you two are court appointed. I want to thank you for your good work on this case and for your argument here on behalf of your client and Ms. Brown. Thank you again for your able representation of the government's interests. We would, as you know, come down from the bench and shake your hands and thank you personally, but even the modern technology doesn't allow us to do that, even if we see each other virtually. But thank you again, and we do hope to see both of you soon in Richmond, God willing. So again, well, thanks very much.
God willing, that day will come and COVID will be a thing of the past.
All right.
Thank you.
May proceed.
Thank you, Your Honor. May it please the court, and good afternoon, Your Honors. I'm Tom DeFranco, appearing on behalf of appellant defendant Terrence DeAndre Dennis. And just to provide you with a brief roadmap, there are two major issues that we would like to discuss with the court this afternoon. The first is what we believe to be the district court's clear error in its decision on Mr. Dennis's motion pursuant to Batson v. Kentucky. And the second is a sufficiency of the evidence argument. And Your Honors, we would specifically like to focus on counts 1 and 3, which are the conspiracy count and the firearm possession in furtherance of a drug offense count. But moving into a discussion of the Batson issue, we believe that, unfortunately, the district court's analysis of the Batson question was somewhat muddled, but there were several clear errors of law made by the district court judge. The first being a reflection that he was aware of no basis of law upon which to make a determination based on the racial composition of the jury, which is in direct contravention of this court's ruling in U.S. v. Joe, which indicates quite clearly that the racial composition of the jury is in fact a factor that may be considered by the district court in making a Batson determination. Now, I'm not saying that this fact was directly before the district court, but it's worth mentioning to Your Honors that the city of Newport News, per the last U.S. Census, is 41% African-American and approximately 10% Hispanic. It's a minority white community. And yet, as a result, as a but-for result of the government strike of a juror of a cognizable racial minority group, the government was able to effectively engineer an all-white jury. The second clear error of law was the district court's focus.
Can I stop you there and make sure I understand 2 points? Did you provide, and I don't mean you personally, but whoever represented him, any argument or support for the, what you cite as U.S. versus Joe, that the racial composition should be considered as a factor?
No, Your Honor, that's a fair point. There was some back and
so I just want to make sure I understand. And then the second point, just in understanding the argument you're making, you said that his strike of the woman, which I understand from the transcript have been his first strike, was the but-for cause. But wouldn't after he struck that woman, you struck two minorities after that fact? And so can we really say that it was the but-for cause, given that it came first?
Well, it's a fair point, Your Honor, and perhaps I would only add that we did not strike two minority members of the veneer, but our co-counsel, our co-defendants counsel made the strike. But your point is well taken. There were two strikes of members of a cognizable minority group by defendant Guess's counsel. That said, I don't think that has any bearing on what the court's view of the Batson issue should be, given the clear Supreme Court precedent that even one strike for a impermissible racially motivated reason against a member of a cognizable minority group is too many and enough to sustain a Batson challenge.
Can you tell me why the reason given by the government was not a racially neutral explanation?
Yes, absolutely, Judge Floyd. And I think that the problem, so first let me say it was a race neutral reason. Our argument is that it was pretextual, and that was an argument made by counsel for Mr. Dennis to the district court. Now, the government responded, of course, by offering a characteristic that it argued distinguished the white social worker from the Hispanic social worker who was struck, by arguing that, well, she was the victim of a high-speed chase, and this is a case that involved a high-speed flight from the police. But I think what's problematic in this case is that the district court engaged in no comparative analysis of the voir dire. And when you look at the questioning of the white juror number 13.
Can I ask, I'm sorry, again, I mean, you're blaming the district court judge. Did you or your colleague present any comparative analysis to the court? I mean, we typically think of district courts as addressing arguments that are made by counsel. Not that the district court was required to go do work that you didn't argue. And I didn't see any comparative juror analysis put forward by you or your co-counsel.
Well, fair enough, Your Honor, and you're correct that there was, well, so I will back up and say that counsel below did make the point that that not only did the government not strike a white social worker, but actually argued against a motion to strike for cause. I would not characterize counsel below as going quite as far as I'm going here today, and pointing out that, in fact, juror number 32 was not even asked by the government about her status as a social worker and how that might impact her ability to serve on the jury. And I think that call it lack of curiosity is fundamentally problematic. And both the Supreme Court and sister courts of this court have acknowledged the fact that both, one, comparative analysis of voir dire by the court is a useful mechanism to examine whether pretext exists in a racially neutral justification that is offered by the government in support of a strike, and two, that the lack of questioning on an issue that the government identifies as a but-for cause for its strike is evidence of pretext. And that's what we had here. The government lawyer below offered a quite detailed explanation to the court as to why he was troubled by the Hispanic juror's employment status as a social worker. He explained that his daughter was employed in the profession, and that in his personal experience, social workers tended to favor individuals of the defendant's socioeconomic position. And yet, in spite of those strong feelings, when given an opportunity to question juror number 32, the attorney for the government did not ask a single question as to how her profession might bear on her ability to fairly judge the trial. If this was an issue that he was truly as motivated about as he expressed to the court, we would expect at least some probing as to how this juror might be able to adequately serve, rather than just a immediate conclusion that, oh, well, because she was in a car accident, it doesn't matter anymore that she was a social worker. That really, it doesn't follow. And so I'd like to point to one other, what we view to be clear error of law by the district court on this Batson issue, which is its focus to the exclusion of all else, seemingly, on the fact that the government used only a certain percentage of its strikes on a member of a racially cognizable minority group, which is in direct contravention to jurisprudence on Batson, both within this court and the Supreme Court. It really should not matter to the district court's analysis that the government struck one white veneer person and thus only used 50% of its strikes when engaged in voir dire. And finally, I would just note one other factor that troubled us was a comment by the district court that, sort of left the impression that the district court didn't take the Batson inquiry as seriously as it should have, which is at Joint Appendix 134, the district court says, I'll just say it, I think that they may not believe that that was the intention, but out of an abundance of caution, felt they needed to make the motion. And that sort of...
So let me ask that question. That's a good question, because, if we were reviewing that factual statement for clear error, Mr. Dennis's lawyer says, with respect to the prosecutor, I don't think you're discriminating. I personally don't think you're discriminating, right? At JA 135. I mean, the defense lawyer says that, right? So if the judge then turns around and says, it doesn't seem like this is anything other than exactly what the district court said. I mean, I don't know that matters, but seems consistent with the record to me.
Well, I apologize, Your Honor. I don't have the ability to scrutinize JA 135 as much as I would like to in answer to your question, but...
Or 126, where he says, well, I'm a sort of Batson motion.
No, so
I
Your
feel like
Honor,
I'm doing something. I mean,
yes,
I'm not sure why this matters, but to the extent that that's your consternation, I'm not sure that that's a mischaracterization of the way counsel themselves presented it, no?
Well, so Your Honor, I believe you're quoting the attorney for Mr. Guess, who in fact did not make the Batson motion, who said I'm sort of making a sort of Batson motion, and then referred to the fact that he was troubled with the racial composition of the jury without clearly making a motion, though I may be misremembering the record. And I apologize for that. I will review it and come back to you on rebuttal. With that said, and if there are no more questions on the Batson issue, I'd like to move on to discuss the sufficiency argument. And moving first to count one, we believe there is a lack of sufficient evidence presented by the government to show that Mr. Dennis and Mr. Guess were engaged in a conspiracy, specifically that Mr. Dennis had any knowledge of the conspiracy before the facts at issue took place. The government basically presented two critical pieces of evidence on this point, that Mr. Dennis was observed in a parking lot with Mr. Guess, interacting with a car that was being surveilled for suspected drug activity, and then that Mr. Dennis was observed by a police officer throwing a bag of heroin and a firearm from Mr. Guess's car while in flight from the police. There is absolutely no evidence presented to the jury below that goes to the question of Mr. Dennis or Mr. Guess's relationship, any sort of agreement that they might have had before, to acquire and distribute narcotics. The record is really barren on this point. And it's worth pointing out that the government had ample opportunity to develop such a case. They in fact seized cell phones from both Mr. Guess and Mr. Dennis and had ample opportunity to return to the parking lot in question to take witness testimony and gain security camera footage, and in fact did not attempt to do so until months after the arrests of both defendants, when witnesses didn't remember seeing them and the security camera footage in question wasn't available because it had been deleted approximately a month after, or the supposition was that it had been deleted.
Mr. DeFranco, if we credit the officer's testimony that it was Mr. Dennis who in fact threw the bag of heroin and the weapon outside of the car, if we accept that to be factually sufficient, is it your argument that that is not enough evidence of a concert of actions that would support the conspiracy count?
I think that's enough on count 2, Judge Diaz, but I don't think it's enough on count 1 to establish that Mr. Dennis knew of the conspiracy before he participated in it. I think that there was ample cause for reasonable doubt before the jury based on the lack of evidence that was presented to them on the relationship between Mr. Dennis and Mr. Guess and exactly what went on in that car prior to the evidence being discarded. Though, I certainly understand that it's the government's position that the discarding the evidence in combination with Mr. Guess's flight from the police is enough, as you suggested. If there are no more questions on the conspiracy count, I'd like very briefly to discuss count 3. And here, the fatal flaw in the government's case is, all they have presented is evidence that a firearm was discarded from the vehicle shortly after or in short proximity to a bag of heroin being discarded from the vehicle. There's no evidence actually presented that the firearm was used to facilitate a drug crime. None of the witnesses presented by the government who saw Mr. Dennis interacting with P, the individual being surveilled in the parking lot, witnessed Mr. Dennis using a firearm, and there's no evidence presented about the proximity of the firearm to the gun while it was within the car. And I see that my time is up. So unless there are any further questions, I will come back on rebuttal. Thank you.
All right, thank you, Mr. DeFranco. Mr. Osif, do I have that right?
Yes, Judge. Mr. Osif, thank you.
You may proceed.
Honors, may it please the court, Peter Osif on behalf of the United States. I'll first address the Batson issues, and to be fair, this is no fault of Mr. DeFranco or even Mr. Bryant who authored the brief for the appellant, but this is clearly an issue where the lack of firsthand knowledge being in the trial court has led to some misstatements of facts here. First, the jury was not all white. There were minorities on the jury. Second, as Judge Richardson, as you already addressed, the but-for argument must fail in the sense that the government wasn't the sole reason that there were no African Americans on the jury. Can you go back to the
first point and point me to where in the JA I can find that the jury was not all white?
Understandably, Your Honor, I don't know that there is a point I can point in the JA for that. But
because during it, or maybe just help me understand, because the defense lawyers seem to suggest that it's all white before they make the Batson motion, and I guess that itself is not a fact that I can rely on because it's just a representation. But well, I mean, I understand you were there and you saw it, but I need something other than that. Why should I find ambiguity on that point?
I understand your point, Your Honor, but again, I unfortunately can't point you to a place that it affirmatively says in the JA that there are other minorities on the panel that was selected. But there's also nowhere that says there aren't. I know that's a horrible answer to your question, but the fact is remains that every step of this issue was initiated by the hyper-cautious Chief Judge Davis. If you read the JA, as soon as the jury was called and roll was taken, there was a brief pause, and Chief Judge Davis asked counsel to approach. The whole thing was initiated by the district court, and asked Mr. Matthews if he was satisfied, Ms. Connor if she was satisfied, and then my co-counsel, Mr. Slotnick, if he was satisfied. And then began a kind of pseudo Batson analysis before a motion was even made, just because of the fact that there were no African Americans seated on the jury, which the government, again, there's no denying that, but that's not a basis for a Batson motion. The JA reflects that Chief Judge Davis goes on to repeatedly say that there's no prima facie case here. Mr. Zlotnick, my co-counsel, went to step 2 anyway and offered a race-neutral explanation, to which the defense had no reason to point to that it was pretextual. The argument, this gets to my third point of factual misrepresentation, that again, I'd like you to look at JA 71 through 75. That's the best place I can show for to prove this point, Your Honors, that the jury voir dire procedure, there was no opportunity for the government to ask juror number 32 any questions. The way it procedurally, the voir dire proceeded was that Chief Judge Davis asked a certain amount of agreed upon questions. Any juror who raised their hand in the affirmative could then either answer from the gallery or come up to the bench and speak in private. Juror number 32 made no such affirmative answers and was therefore not subject to any additional voir dire. The other social worker that Ms. Connor had pointed to as a pretextual, or in reference to her pretextual argument, did answer affirmatively that she had been a party to a witness or a victim in a crime, and that crime, as Mr. DeFranco pointed out, was similar in a similar fact pattern that we saw in this case. So Mr. Zlotnick articulated that he thought that outweighed the fact that she was a social worker, and I believe JA 132, Mr. Zlotnick said, if I had other information, referring to juror number 32, if it had only been the fact that she was a social worker, not the other aspect of it, I would have certainly made that challenge. He admitted that he would have struck the other social worker as well, but for the fact that she had been a party to a similar fact pattern situation, and he had taken the time to rehabilitate her and make sure that that wouldn't make her be an impartial or just juror, which she did. She answered affirmatively, and there was no further challenges at that point. Those are the three main factual discrepancies with the appellant's arguments regarding the Batson issue. And again, Chief Judge Davis was extremely cautious, and at every point, all three prongs of this test fail, and therefore there's certainly no clear error on the court's ruling. As for the sufficiency of the facts at issue, Your Honor, in 1996, this court in United States v. Burgos firmly established that conspiracy, by its very nature, is clandestine and covert, thereby frequently resulting in little direct evidence, and therefore circumstantial evidence can be the wholly provable evidence for a conspiracy. Burgos and its progeny, up to and including this court's published opinion as recently as June 22nd of this year, in United States v. Moody, have continued to hold that the fact that a conspiracy is loosely knit, haphazard, or ill-conceived does not render it any less a conspiracy or any less unlawful. The Supreme Court has admonished that a reviewing court not examine evidence in a piecemeal fashion, but consider it in a cumulative context. In this court, Your Honors, this court may not overturn a substantially supported verdict merely because it finds the verdict unpalatable or determine that another reasonable verdict would have been preferable. The jury verdict must be sustained if there's substantial evidence taken in the view most favorable to the government to support it. The reasonable inferences were made here from a string of facts that I would argue are far more than were seen in the Moody case, where this court reluctantly but correctly held and I think established a baseline for what constitutes a criminal conspiracy. Great deference is given to trial verdicts for good reason, Your Honors. A jury is in a far better position to review and analyze the evidence in real time, to assess factors inaccessible to the reviewing body from a cold record, and to take as much time as needed to deliberate, ask questions, and deduce reasonable inferences from all the evidence presented at trial, which the jury did in this case in spades. They deliberated, they asked questions, and to that point, Your Honor, they did not, they acquitted Mr. Guess of the firearm charges. So this was not a rubber stamped quick, they must be guilty type verdict. It was deliberate, it was careful, and it was proper. Your Honors, I thank you for your time and service, and I'm happy to field any additional questions that you may have. Otherwise, the U.S. stands on its brief, and I respectfully ask the court to affirm the convictions in this case.
All right. Thank you, Mr. Ossoff. Mr. DeFranco, you've got some time for rebuttal.
Thank you, Your Honor. And I guess let me first address Mr. Ossoff's point about the composition of the jury. If I've made any factual misstatement, obviously that's on me, and I apologize. That was my representations were made in both reliance on the record and in consultation with some of my colleagues. I'm not here to contravene anything Mr. Ossoff, who was at trial, has said about the composition of the jury. So I apologize for that. That said, whether or not the jury was all white, I think the record does clearly establish that it was a jury with a racial composition that could have been taken into consideration by the court. And so we stand on our argument that the court committed clear error by failing to acknowledge that racial composition of the jury was in fact a factor that could have been considered in reviewing the Batson charge. Mr. Ossoff then argued that the government wasn't the sole reason for an all-white jury, which I think we addressed earlier. I don't think that really has any bearing on the Batson analysis. If the court finds that the government did in fact use a strike for a impermissible racially motivated reason, the fact that defense counsel also struck members of a cognizable racial minority group is of no moment to the Batson analysis. Third, Mr. Ossoff focused on the fact that the district court found that there was no prima facie showing under Batson, but as I think we briefed, that really doesn't matter at this stage, because it is the jurisprudence of the Fourth Circuit that once the district court goes beyond the prima facie stage and gives the government an opportunity to provide a race-neutral justification for its strike, a determination on Batson at the appellate level will not be predicated on whether or not there was a prima facie showing. So your decision on this issue should not be based on the district court's finding with regard to whether or not there was a prima facie case. Fourth, and finally, in response to the questioning of jurors, it was certainly Mr. Ossoff characterized this as a misstatement of fact. I respectfully disagree with him. I think what our papers say is simply that there was no questioning of the Hispanic juror on the issue of her status as a social worker, which is true, as he said in his argument. And what we really seized on was the fact that there was an opportunity to question this white juror, and as he said, an opportunity to rehabilitate her as a witness. And yet in that questioning, no questions were asked with regard to how her employment as a social worker might bear on her ability to serve as a member of the veneer. And that is what is troubling.
So it's fair to say neither juror was asked about social work? Yes,
fair to say, Your Honor. And I'd just like to go I have had an opportunity to look at the joint appendix, Your Honor, and I believe that the quote you pulled from page 126 was in fact from counsel for Mr. Guess, who did not make the Batson motion that was made by Mr. Dennis. I believe he joined in it at some point. And then at JA 135, I think the quote is from Mr. Connor is that she has nothing against Mr. Zlotnick personally. I didn't see, though I was reading quickly, but I didn't see her say, I don't think, I'm paraphrasing, Your Honor, but I didn't see her say, I don't think that you, engaged in a strike for with a racially impermissible motivation. Moving quickly to the sufficiency argument, I'd like to briefly discuss the Moody decision, which Mr. Ossoff discussed, and I think that decision is distinguishable from the current set of facts. What was critical to the court in Moody was the fact that the government actually had introduced some limited evidence regarding the relationship between the two co-defendants in that case. In fact, the court emphasized that it was troubled by the lack of evidence presented establishing any kind of connection between the two defendants, but that there was some testimony on the fact that one defendant had referred to the other as, quote, my girl, and that was enough to establish some pre-existing relationship before the drugs, guns, and money had been acquired during in that fact pattern. We don't have any kind of evidence in this case relating to Mr. Guess and Dennis. And with that, I see my time has expired, so I respectfully ask the court reverse the district court's Rule 29 motion, or in the alternative, grant Mr. Guess a new trial on the Batson issue. And thank you all for your time.
Thank you, Mr. DeFranco and Mr. Ossoff, both for your arguments here this afternoon. We certainly appreciate them both. And as I indicated to your colleagues earlier this afternoon, we would typically come down from the bench and greet you personally. We can't do that, obviously, but hope to do that again soon. Until then, thanks again for your arguments, and we will adjourn court. Sanida.
Thank you, Your Honors.
Thank you, Your Honor.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.